The billing alert arrived at 2:17 a.m. on a Tuesday, flagging per diem charges I never authorized. I stared at my laptop screen in the dim light of my home office, coffee growing cold beside a stack of civil rights case files. Archibald Friedman, 42 years old, staff attorney at our Little Rock firm, specializing in employment discrimination and constitutional violations. 15 years of practice had taught me to trust my instincts about irregularities. The email subject line read, "Account code 4471AF, unusual activity detected. My account code. My cases." But the charges listed made no sense. Per diem expenses for travel to Memphis. 3 separate entries, totaling $847.50. All approved under my digital signature. All dated last week while I was in depositions for the Henderson workplace harassment case, never leaving Pulaski County. I clicked through the firm's case management system, fingers moving quickly across familiar screens. The billing entries showed detailed breakdowns, hotel stays, meal allowances, mileage reimbursements, professional formatting, proper documentation codes. Everything appeared legitimate except for one critical detail. I was never in Memphis. The system log showed my user credentials approving each charge. Timestamps indicated I had personally reviewed and authorized the expenses at 11:43 p.m. on Thursday. That night, I was home, grading my daughter's algebra homework and reviewing discovery motions until well past midnight. Someone had accessed my account. Someone with sophisticated knowledge of our billing procedures and approval protocols. Someone who understood exactly how to make fraudulent charges appear routine. I scrolled through months of previous billing statements, searching for patterns. The Memphis charges weren't isolated incidents. Similar entries appeared sporadically over the past 6 months. Atlanta, Nashville, Birmingham. Always per diem expenses. Always approved under my credentials. Always during periods when I could verify my actual location through court records or client meetings. The total amount exceeded $4,000. My hands trembled slightly as I reached for my phone. The firm's security consultant, Fitzgerald Kensington, had implemented our new digital billing system 8 months ago. He possessed administrative access to all attorney accounts. He had trained us personally on the approval protocols. He had praised my work openly to other partners during the implementation meetings. The pieces aligned with uncomfortable clarity. But accusing a trusted colleague of systematic theft required more than suspicious billing entries and circumstantial timing. I needed concrete. Digital fingerprints. Irrefutable proof. I opened a new document and began documenting everything: timestamps, amounts, corresponding calendar entries proving my whereabouts. The investigation would require careful planning and absolute discretion, because if Fitzgerald was stealing from my account, he was likely stealing from others. The investigation began at dawn. I arrived at the office 2 hours before normal business hours, when the building hummed with only security systems and automated backups. The early morning silence provided perfect cover for what I needed to accomplish. Our case management system maintained detailed access logs for every user interaction. As a senior staff attorney with administrative privileges for my own cases, I could review login patterns and document access histories. What I discovered in those first quiet hours changed everything. Fitzgerald's digital footprint revealed a disturbing pattern. His administrative account showed regular after-hours access to attorney billing modules, always between 11 p.m. and 2 a.m. The timestamps corresponded precisely with the fraudulent per diem approvals I had identified in my own account, but the scope extended far beyond my billing code. I cross-referenced his access logs with partner billing statements from the past 8 months. The pattern emerged with mathematical precision. Fitzgerald had systematically accessed 12 different attorney accounts, approving fictitious travel expenses totaling over $37,000. The methodology was sophisticated. He rotated between accounts to avoid detection. He varied the amounts to prevent algorithmic fraud alerts. He selected attorneys with heavy travel schedules to provide plausible cover. He understood our internal controls better than most partners, because he had designed them. My phone buzzed with a text message from Valentina Ashworth, our senior paralegal and my most trusted colleague. Coffee? Need to discuss something urgent. We met at a diner 6 blocks from the office. Valentina's expression carried the weight of serious concern as she slid into the booth across from me. "I've been tracking some irregularities," she said quietly. "Client trust account reconciliations aren't matching our internal records. Small discrepancies, but consistent patterns." I leaned. "What kind of patterns?" "Expense reimbursements that don't correspond to actual case activities. Travel costs for depositions that never happened. Per diem charges for court appearances in cities where we had no scheduled hearings." She produced a manila folder containing printed spreadsheets. Her analysis revealed the same systematic fraud I had discovered, but from a different angle. While I had focused on billing approvals, Valentina had identified the accounting irregularities that resulted from those approvals. "How long have you been tracking this?" I asked. 3 weeks. I wanted to be certain before raising concerns. The amounts seemed too small for deliberate fraud, but the patterns were too consistent for clerical errors. I shared my findings about Fitzgerald's administrative access and the fraudulent approvals under my credentials. Valentina's face darkened as the implications became clear. "He has complete access to our financial systems," she said. "Client accounts, operating expenses, partner distributions. If he's stealing from billing codes, what else might he be manipulating?" We spent the next hour comparing our fansu. The picture that emerged was damning. Fitzgerald had exploited his position as security consultant to systematically steal from the firm through fraudulent expense approvals. His technical expertise had allowed him to cover his tracks while maintaining the appearance of legitimate business activities. But we needed more than spreadsheets and access logs to build a case. "We need to document his real-time activities," I said. "Catch him in the of approving fraudulent charges." Valentina nodded. "I can monitor the accounting system for unusual after-hours activity. If he follows his established pattern, he'll access the billing module again within the next few days." We agreed to maintain normal routines while gathering additional. Any change in behavior might alert Fitzgerald to our investigation. The stakes were too high for premature action. That afternoon, I reviewed Fitzgerald's personnel file through legitimate channels. His background check had been thorough. Previous employers provided glowing recommendations. His technical certifications were current and verified. Nothing suggested criminal tendencies or financial desperation. Yet the surbelia was irrefutable. During the weekly partners meeting, I observed Fitzgerald's interactions with careful attention. He participated normally in discussions about case management upgrades and security protocols. His demeanor remained professional and confident. He showed no signs of stress or suspicious behavior. The performance was flawless. After the meeting, senior partner Valentina Blackwood approached me privately. "Archibald, I've received some unusual questions from our malpractice insurance carrier. They're requesting documentation for travel expenses that seem inconsistent with our case files." My pulse quickened. What kind of inconsistencies? Reimbursements for depositions in Memphis and Atlanta that don't correspond to any active litigation. The insurance company flagged them during their routine audit of our professional liability coverage. The external scrutiny added urgency to our investigation. If the insurance carrier had identified irregularities, other oversight bodies might soon follow. We needed to resolve this internally before it escalated to bar complaints or criminal investigations. That evening, Valentina Ashworth called with critical information. "He's accessing the system now. Real-time billing approvals for travel expenses under 3 different attorney codes." I drove to the office immediately. The parking garage was nearly empty except for Fitzgerald's sedan in its usual spot near the security office. The building's after-hours access logs would show my entry, but I had legitimate reasons to retrieve case files for weekend preparation. From my office, I could monitor the billing system remotely. The screen displayed Fitzgerald's active session, showing him navigating through attorney expense accounts with administrative privileges. As I watched, he approved per diem charges for a fictitious deposition in Nashville under partner Valentina Sterling's billing code. The amount was $847, I captured screenshots of every transaction, documenting the exact timestamps and approval sequences. The ash was now overwhelming and irrefutable. Fitzgerald Kensington had systematically defrauded the firm of tens of thousands of dollars through sophisticated manipulation of our billing systems. But confronting him required careful strategy. His administrative access could allow him to delete or manipulate records if he suspected discovery. We needed to secure all documentation before taking action. The next morning brought an unexpected development. Fitzgerald requested a private meeting to discuss security concerns he had identified in our case management system. His calm demeanor and professional tone suggested no awareness of our investigation. "I've discovered some irregularities in our billing protocols," he said, settling into the chair across from my desk. "Unauthorized access patterns that suggest potential fraud." The audacity was breathtaking. He was positioning himself as the discoverer of the very crimes he had committed. "What kind of irregularities?" I asked, maintaining neutral expression. "Expense approvals that don't match attorney travel schedules. Per diem charges for court appearances that never occurred. Someone with administrative access has been manipulating our financial systems." He produced a folder containing printed reports that documented his own fraudulent activities, presented as of unknown criminal behavior. The psychological manipulation was sophisticated and calculated. "I recommend immediate implementation of enhanced security protocols," he continued. "We should also consider involving external auditors to assess the full scope of potential losses." I nodded thoughtfully, as if considering his recommendations. "How long do you estimate this has been occurring?" "Based on the patterns I've identified, approximately 8 months. The perpetrator clearly understands our internal systems and has been careful to avoid detection." 8 months. Exactly the period since Fitzgerald had implemented our new billing system and gained administrative access to all attorney accounts. The meeting concluded with his promise to provide detailed recommendations for preventing future security breaches. His performance had been flawless, but the against him was now complete and documented. That afternoon, I met with Valentina Ashworth to plan our next steps. The situation required immediate action to prevent further theft and protect the firm's reputation. "We have enough for criminal charges," she said, "but we should also consider the potential impact on client relationships and ongoing litigation." I agreed. The firm's response would need to balance justice with practical considerations about business continuity and professional obligations. The investigation had revealed the full scope of Fitzgerald's betrayal: systematic theft, sophisticated manipulation, and calculated deception spanning 8 months. The total amount exceeded $37,000, with suggesting ongoing criminal activity. But the most disturbing aspect was his attempt to frame unknown perpetrators for his own crimes, while positioning himself as the solution to security problems he had created. The time for confrontation had arrived. The confrontation took place in Conference Room B at 9:15 Monday morning. I had requested Valentina Ashworth's presence as a witness, along with managing partner Fitzgerald Blackwood. The security consultant arrived precisely on time, carrying his leather portfolio and wearing the same confident expression that had fooled us for months. "Thank you for accommodating this urgent meeting," I began, placing the folder on the conference table. "We've completed our internal investigation into the billing irregularities." Fitzgerald Kensington leaned with apparent interest. "Excellent. I'm eager to review your findings and coordinate with my security assessment." I opened the folder and spread the printed reports across the mahogany surface. Bank statements, billing records, system access logs, and time-stamped screenshots formed a comprehensive timeline of his criminal activities. "These documents show systematic theft of client funds through fraudulent per diem charges," I said. "The perpetrator used administrative access to approve fictitious expenses under multiple attorney account codes." His eyes moved across the papers, and I watched his expression shift from professional curiosity to careful calculation. The confident mask remained, but something changed behind his eyes. "This is precisely what I suspected," he said smoothly. "The sophistication suggests insider knowledge of our billing protocols." "Have you identified any suspects?" Valentina Ashworth spoke for the first time. "Yes, we have." I placed the final document on the table. a detailed analysis showing how each fraudulent charge corresponded exactly with his system access times. The Weiss was irrefutable and comprehensive. These logs show that every fictitious per diem charge was approved from your administrative account, I continued. The timestamps match your documented presence in the office, and the IP addresses traced to your assigned workstation. The silence stretched for nearly 30 seconds. Fitzgerald Kensington studied the documents with the same analytical attention he had shown during his security presentations. When he finally looked up, the pretense was gone. "You've been thorough," he said quietly. "More thorough than I anticipated." Fitzgerald Blackwood leaned back in his chair, his face reflecting a mixture of disappointment and professional concern. "How long has this been occurring?" 8 months, I replied, beginning shortly after he gained administrative access to our billing system. The total amount stolen exceeds $37,000. The managing partner's expression hardened. "This represents a fundamental breach of trust and professional ethics. The firm will pursue all available legal remedies." Fitzgerald Kensington remained calm, as if discussing routine business matters. "I assume you'll be contacting law enforcement and the State Bar Association." "That process has already begun," Valentina Ashworth confirmed. "We filed a complaint with the Little Rock Police Department this morning, and the Arkansas State Bar has been notified of potential criminal activity involving client funds." I had also contacted the Client Trust Audit Authority, knowing that Dr. Rachel Kim's investigation would be thorough and impartial. Her reputation for uncovering financial irregularities in legal practices was well established throughout the state. "The Bar Ethics Council will conduct an independent review," I added. "Dr. Rachel Kim has been assigned to oversee the audit of our client trust accounts and billing procedures." The mention of Dr. Kim's involvement seemed to register with him. Her investigations had resulted in numerous disciplinary actions and criminal referrals over the past decade. "I won't insult your intelligence by denying he said finally. "But I want you to understand that this wasn't personal. It was simply an opportunity that presented itself." Valentina Ashworth's voice carried a sharp edge. "You stole from clients who trusted us to protect their interests. You manipulated our security systems and attempted to frame innocent parties for your crimes." "The security vulnerabilities were real," he replied. "I simply took advantage of weaknesses that already existed in your protocols." Fitzgerald Blackwood stood abruptly. "This meeting is concluded. You're terminated immediately, and all access to firm systems has been revoked. Security will escort you from the building." The next 3 weeks brought a cascade of legal and professional consequences. Dr. Rachel Kim's audit revealed additional irregularities in expense reporting and client billing that extended the investigation timeline. Her team worked methodically through 18 months of financial records, uncovering patterns of manipulation that predated our initial discovery. The Arkansas State Bar moved quickly to protect affected clients. Emergency measures were implemented to ensure no client suffered financial harm from the theft, and the firm established a victim compensation fund to address any remaining concerns. Criminal charges were filed within 10 days. The prosecutor's office treated the case as aggravated theft due to the systematic nature of the fraud and the breach of fiduciary duty involved. The package we provided formed the foundation of their case. Fitzgerald Kensington's attorney attempted to negotiate a plea agreement, but the prosecutor insisted on felony charges given the sophisticated nature of the scheme and the violation of professional trust. The case proceeded to trial within 6 months. During this period, I worked closely with affected clients to rebuild their confidence in our representation. Several cases required additional documentation to satisfy court requirements, but no client withdrew their business due to the security breach. The firm implemented comprehensive reforms to prevent future incidents. New oversight procedures, enhanced system monitoring, and mandatory background checks for all consultants became standard practice. These changes were costly but necessary to restore institutional integrity. Dr. Rachel Kim's final report praised our cooperation and recommended our reforms as a model for other practices. Her investigation found no additional wrongdoing by firm personnel, confirming that the theft was an isolated incident perpetrated by a single individual. The trial concluded with guilty verdicts on all charges. Fitzgerald Kensington received a sentence of 4 years in state prison, with restitution ordered for the full amount stolen plus interest and penalties. The judge noted the sophisticated nature of the fraud and the defendant's abuse of professional trust in determining the sentence. But the most significant outcome was the broader impact on legal security practices. Our experience became a case study for bar associations across the region, highlighting vulnerabilities in modern law firm technology and the need for enhanced oversight of external consultants. I testified before the Arkansas State Bar's Ethics Committee about the incident, providing detailed recommendations for preventing similar breaches. The committee adopted several of our proposed reforms as mandatory requirements for all member firms. The betrayal had cost us financially and professionally, but it also strengthened our commitment to ethical practice and client protection. The firm emerged from the crisis with enhanced security measures and a renewed focus on institutional integrity. 6 months after the trial, I received a call from the Tennessee Bar Association requesting consultation on a similar case involving fraudulent billing by a technology consultant. The patterns were remarkably similar to our experience, suggesting that such schemes might be more widespread than initially believed. 12 months later, I stood in my new office overlooking the Arkansas River, watching morning light reflect off the water's surface. The nameplate on my door read, Archibald Friedman, Managing Partner. I'd never expected to hold at 43. After the Fitzgerald Kensington incident, 3 senior partners at my former firm decided early retirement was preferable to rebuilding trust with clients. The remaining partners offered me a leadership role, but the memories were too fresh. Too many late nights reviewing billing records. Too many conversations about security breaches. Instead, I joined 2 colleagues in establishing a new practice focused exclusively on civil rights litigation. We started small, 3 attorneys, 1 paralegal, and a commitment to transparency that bordered on obsessive. Every billing entry required dual approval. Every consultant underwent extensive background verification. Every system access was logged and monitored. The irony wasn't lost on me. Fitzgerald's betrayal had made me a better attorney and administrator. The paranoia he'd instilled became professional vigilance. The skepticism he'd earned became healthy oversight. Our first major case involved representing whistleblowers at a manufacturing plant who'd reported safety violations. The parallels to my own experience weren't subtle. Employees discovering systematic deception, struggling with institutional loyalty, ultimately choosing disclosure over silence. Dr. Rachel Kim contacted me quarterly for updates on our security implementations. Her follow-up reports consistently rated our procedures as exemplary, noting that our reforms had influenced Bar Association guidelines in 4 states. Other firms began adopting similar oversight mechanisms. The Tennessee case I'd consulted on resulted in another conviction. The consultant there had used nearly identical methods, exploiting system vulnerabilities during high-stress periods when attorneys were focused on case deadlines rather than administrative details. The pattern suggested a broader network of fraudulent consultants targeting law firms. I helped propose ethics oversight boards in multiple states, drawing from our experience to advocate for mandatory security audits and consultant verification requirements. The Arkansas State Bar implemented these recommendations as binding regulations for all member firms. Fitzgerald Kensington served 18 months before receiving parole for good behavior. His law license remained permanently revoked, and civil judgments prevented him from working in any capacity involving financial systems or client funds. The restitution payments continued monthly, a reminder of consequences that extended far beyond prison walls. My former colleagues occasionally reached out with updates. The firm had recovered financially but never regained its previous reputation. Client relationships required constant reassurance. New business came slowly, earned through demonstrated competence rather than inherited trust. The betrayal had taught me that institutional loyalty meant nothing without individual integrity, that sophisticated systems were only as secure as their weakest human element, that professional relationships required constant verification rather than blind faith. My new practice thrived on these principles. Clients appreciated our transparency protocols. Opposing counsel respected our meticulous documentation. The Bar Association frequently cited our procedures as best practices for emerging firms. The river below continued its steady flow toward the Mississippi, carrying debris and sediment toward larger waters. Some mornings I watched barges navigate the current, their progress steady but cautious. The metaphor felt appropriate, moving while remaining alert to hidden obstacles. The phone rang less frequently with crisis calls now. The late-night billing alerts had been replaced by routine system reports. The paranoia had evolved into professional caution, a healthy skepticism that protected both clients and colleagues. It was finally over, and the silence felt earned.